Welcome everybody to Contractor's Guide to Securing Proof of Owner Financing webinar. This presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without written permission of the speaker is prohibited. The statements expressed by speakers, panelists, and other participants reflect their own views and do not necessarily reflect the views or positions of ACD Operations, the American Institute of Architects, or of the AIA components, or those of those respective officers, directors, members, employees, or other organizations, groups, or individuals associated with them. So just a small disclaimer before we get started, this presentation and accompanying materials have been provided for general AIA contract document informational purposes only. The information is not provided as legal advice. The information provided cannot be used for mediation, arbitration, or litigation purposes. Transmission and/or receipt of this information does not create an attorney-client relationship. No one should act upon this information without seeking appropriate legal counsel on the particular facts and circumstances at issue. So before we get started today, I'll introduce our experts, our presenters. Michael Bamba, Managing Director and Counsel at AIA Contract Documents, and as well joined by Cody Thomas, Manager and Counsel at AIA Contract Documents. And with that, I'll throw it to you, Michael.
Thank you, Nadia. Before we get started, just a little bit more, I guess, about my background. My name is Michael Bamba. I've been with the Contract Documents program for 18 years. I started in 2006, and so one of my first assignments was finishing up the A201 2007, which we'll talk a little bit about throughout this program. And I've worked on a number of documents throughout that time since, and today we're here to talk about primarily the new owner finance forms. But before we get into the forms themselves, the G728 and the G729, I think it makes some sense to understand the background about what these forms really are responding to, which are a means by which the contractor can make a request to the owner to get evidence of reasonable evidence of the owner's financial arrangements for its obligations under the construction contract. Many of our documents have provisions that specifically address and provide the contractor with this ability to make this type of a request on the owner. And as you'll see in some of the slides coming up, it's actually been in the documents in some form for a while. Almost, I think, close to 45 or 50 years, depending, once we can do the math once we get to those slides. But for a long time, there's been some version of a provision that has allowed the contractor to make at least some kind of a request to the owner to find out what sort of financial arrangements it's had made, and whether or not they have made proper arrangements to fulfill the owner's obligations under the contract. Those provisions have evolved over the last few decades to what we have now in the current version of the A201, and many of our other documents that are similar to or based on the A201. But we've never had any type of mechanism by which the contractor and the owner could go through this process of making a request from the contractor side, and then once the owner receives it, having some sort of form and guidance on sort of what type of information to provide back to the contractor. So we'll go over those forms. There's not a lot to them in terms of written substance, but we'll go through the way they're set up and what type of information they ask for later on in the presentation. But before we get to that, I wanted to do a little bit more background about why we even have this type of provision in the agreements. Why do you provide an opportunity for the contractor to access the owner's financial information? And it really comes down to it's kind of the fair and reasonable option, given the relationship between the two parties. the owner will have an opportunity, substantial opportunity actually, to vet the contractor on a number of fronts when they go through the bidding process. The owner will, obviously everyone knows, the owner will put out a RFP probably and get multiple responses back from contractors, and as part of that process, the contractors will, they'll have to state and explain their capacity to do the project, not only from a skill and experience standpoint, but they're typically also required to show what type of financial stability they have to allow them to do the project. Contractors, conversely, don't really have that same opportunity. And when you think about, how a project actually works, the contractor outlays a fair amount of expenses at the beginning of the project, and most projects are going to be reimbursed, or payments to the contractor occur on a monthly basis, but those are reimbursement style, where the contractor is typically, and the subs have typically already expended the money that they needed to start the project and to begin construction or whatever is required by the work of the contract. So they're already outlaying all of these funds, but they have not necessarily had the same opportunity to vet the owner's financial stability. So there's a lot of risk involved for contractors if the owner doesn't have the finances in place to pay the contractor. I mean, not just pay them, but pay them timely. There are mechanisms within the agreements by which the contractor can protect themselves. They can stop work. They can suspend their services, and they may have the ability to pursue liens lien the property if things get really bad. But obviously, anyone who's tried to lien property and recover based on a lien, it's not necessarily a quick process. It usually takes a fair amount of time, but the contractors and the subs are already out whatever money they've expended. So you think about that, where an owner or contractor has to sign the agreement, most likely commence the work fairly soon after signing the agreement, without having much exposure to, what kind of financial wherewithal the owner may have. And you think about the types of owners that might be involved. Sure, you might have a well-established company or institution that's been in business for a long time. Not to say that they can't have financial constraints, especially because construction is so expensive. But a lot of construction is done by single-purpose entities that are formed, LLCs that are funded only for the project. They don't actually carry a lot of capital on the books because they're not ongoing businesses. They are just formed for the purposes of doing that construction project. So you compare that situation to what an owner gets when they're trying to figure out which contractors to hire. Not only do they have the benefit of the bidding process, they're probably going to be asking the contractor to bond the project, get payment and performance bonds. And that not only does that provide certain protection to the owner in terms of financial backing of the surety company, if the contractor is not able to pay performance services or pay its subs. The fact that the contractor has this bonding capacity is in of itself a reflection of the contractor's strength and ability to do the project, because to get that bonding capacity, the contractor had to go through a lengthy and in-depth vetting process that the surety puts in place to for them to demonstrate that what ability they have to perform projects so that they can achieve certain bonding capacity. So an owner has that extra level of scrutiny that the surety has placed on the contractor. So, being able to get a contractor who can satisfy the bond requirements is another level of protection and assurance to the owner that this contractor is financially stable and is able to fulfill its obligations under the contracts. But as I've said a few times now, the contractors just don't have that same level, that same opportunity to necessarily access the owner's financial stability. So it only seems that it's a reasonable process to allow within the contract some mechanism for the contractor to access, to get information about the owner's financial arrangements, so that it can adequately evaluate its own risk on a project. Now, you'll see as we go through the next slides, this right has, started at commencement, at contract execution. Then it sort of recognizes the need, like, well, it's not just relevant at contract execution. There may be points along throughout the project that the contractor needs to get access to this information. So we've recognized this sort of right for a long time in the documents. But what we've done over these decades is balance that right to access with the owner's interests. And the owner's interests are, obviously, it doesn't want to be constantly peppered for its financial information, and nor does it want to be subject to frivolous requests from the contractor. Certainly once, and from an owner's perspective, if I've provided adequate information to you, you should be continuing on with the project and not making continuous and regular requests for this type of information, because it can be a nuisance to reply to that type of request over and over again. So you'll see as we go through the evolution of the contract language, kind of, where these comments have come in and how they've been responded to over the last few decades. So in the A201 1976, so 48 years ago, this section 321 was added, and that it required the owner, if the contractor requested it, the owner had to provide reasonable evidence that it had made financial arrangements to fulfill its obligations under the contract. Now you'll see that the gist of that language kind of continues throughout over the next few decades in the agreement. Now the provision itself is written a little strangely in the sense that it requires that at the time of execution, the owner shall furnish the reasonable evidence and it has made financial arrangements. And then if that information is not provided, the contractor is not required to execute the owner-contractor agreement. Well, this is the owner-contractor agreement, and this is the provision that requires the owner to do it. So, sort of a chicken or the egg here, where I don't know that there's an obligation on the owner to provide this information until the contract is executed. But one of the protections supposedly to the contractor is that they don't have to execute the agreement. Well, the reality is they've probably already done that. But it also gives them the ability that they don't have to commence the work. And so that's the real protection that was provided to the contractor, in the initial instance of this section making its way into the A201. It gave the contractor the ability to make a request. Had to affirmatively requested it. The owner wasn't just going to provide the information, but once that request was made, the owner had to provide reasonable evidence. If they didn't, then they were not required to commence the work. Now, it's not clear from this language. It's probably not the case that once the contractor commences the work, is there any right for the contractor to request financial information? Not by the provision, not by the strict reading probably of this section. So it's really, the only opportunity was prior to commencement of the work. So that period of time between when the contract was signed and when the contractor was actually going to go out and start beginning the work required under the contract. All right, so 10 years later, the provision stays in. It's moved around a little bit, but it's still a relatively short and discrete section. Again, if the contractor makes the request, the owner, prior to execution of the agreement, and promptly from time to time thereafter, furnish reasonable evidence that financial arrangements have been made to fulfill the owner's obligations. So again, there's sort of that chicken or the egg issue with this language, where the request is a contract provision that the contractor can make the request, and so how you can do it prior to execution of the agreement, not quite sure, but nonetheless, it's there. But what you see added is this additional phrase that now gives the contractor the ability from time to time thereafter to make the request. You can parse through the language about what promptly from time to time modifies, but the idea being that not only does the contractor possibly need this type of information prior to commencement, there may be times throughout the course of the project that they also need that information. And then there was this note added that unless such reasonable evidence were furnished or requested prior to the execution of the agreement, the prospective contractor would not be required to execute the agreement or to commence the work. Obviously, there's no agreement signed, so I don't even know how enforceable that note is, but you kind of get the idea of where the provision is going at this point, taking it from the initial request and the prior to commencement to now being prior to commencement, but also from time to time thereafter. So we revise our documents on a 10-year revision cycle. So now we're up to the A201 1997. The provision is still pretty much this one section, but the request is largely the same. The owner, upon the contractor's request, prior to commencement of the work and thereafter, will be required to furnish reasonable evidence that financial arrangements have been made to fulfill the owner's obligations under the contract. So now we've sort of solved for there's no penalty for doing something before the contract is even executed. We now have fixed the language where the owner is now required to, if they're requested prior to commencement and thereafter, furnish to the contractor the reasonable evidence. And then we have additional language to clarify that the provision of that evidence is now a condition precedent to commencement or continuation of the work. So now, the teeth in the provision have sort of been set now. If the contractor makes the request, whether it's prior to commencement or at some point thereafter, the owner has to provide the reasonable evidence. If they don't, the contractor is not obligated to commence the work, assuming we're prior to commencement, or continue the work. So I think you now see the insinuation in the language that the contractor would have the right to stop the work. It doesn't say it outright, but obviously if there's no obligation to continue the work, they would necessarily need to stop the work. So now the teeth have been put into this provision on what happens if the contractor makes the request and the owner doesn't satisfy the request. Now, what does it mean to satisfy the request? The owner could not respond with anything, in which case, obviously, reasonable evidence hasn't been provided. They could provide minimal information, and then the contractor gets into the decision-making process of whether or not that evidence is sufficient. We'll talk a little bit more about that at the end of the presentation. One thing to note, I think, in this section is there's no real limits or conditions on the contractor on making these requests for financial information. So as you would read this, the contractor can make these requests at any point and as many times as they want throughout the course of the project. And this is where we started to hear, I think, commentary from owners about the overly burdensome nature of the way this provision is written. Obviously a number of people out there were using it, contractors were using it without, any problems on their project, maybe make the request once prior to commencement, or if they had reasonable question about the owner's financial arrangements as the project had proceeded, maybe they missed a payment or there were some trouble getting payment from an owner, they might want to request reasonable assurances, and they could use this provision. From the owner's perspective, though, I'm sure that there were instances where contractors were overly eager to make this request on the owner, and then which obviously it comes with it the risk of not commencing the work, which would then delay the project, or being able to stop or delay the work as they're moving along and throughout the normal commencement of the project. So from an owner's perspective, that could be troublesome if you have a contractor who's repeatedly making this request, even if the information hasn't changed from prior requests. So that then leads to 10 years later to the newer provision in the 2007 documents. So again, the basis is still the same. But now we introduced this, the rights are slightly different depending on where you are in the project. So now you have what I'll refer to as unfettered access to the owner's, unfettered ability to request the owner's financial information, but only prior to commencement. once the and that makes some sense. That's the point when the contractor starts to outlay, starts to go into outlaying cash for the project and incurring those expenses. Prior to commencement, they haven't really done a whole lot in terms of an outlay of expenses for the project. Now, so now we have the change to be, it's a different treatment after commencement. There are certain conditions that must be met before the contractor can make the request. So kind of unfettered right up to commencement of the project. And if you think about an A201 style project, there's not a lot of time probably between execution of the agreement and commencement of the work, but there may be some period of time, but not a lot. But then once you reach that point, the contractor, in a way is assuming some of the risk. You had your opportunity to ask the information. You chose not to. We've now commenced the work. That was your choice as the contractor to do so. And now you can only make the request for reasonable financial evidence if certain conditions are met. And then the provision continues that if the owner that the provision of the information from the owner is a condition precedent commencement of the work or continuation of the work. So we still have it's still an implied ability to stop the work. It's not expressed yet, but again, you can see we're now the attempt to balance the owner's interest in making these types of requests if there's a non-payment or if there's concern on the contractor's part too about the ability of the owner to meet its financial obligations. So again, we're fast forwarding then another 10 years to the most recent A201. We maintained the different rights prior to commencement and after commencement, but we added a lot more detail on the contractor's rights and the repercussions if the owner fails to respond. I think for the prior to commencement, again, it's that sort of unfettered ability to make the request. Again, you don't have a lot of time. There's not a big time window there. So I use the phrase unfettered, but just by the extent of time that exists in that period, you're not going to get multiple and repeated requests. It would be unlikely for that to be the case. So prior to commencement of the work, the owner is required upon if the contractor makes the request to provide reasonable evidence, as we've been talking about. And then if the contractor doesn't get the evidence that it's looking for, they have no obligation to commence the work. And then we provide more clarity about what happens if they don't commence the work. You won't have seen any reference to contract time, I think, in the previous provision. So if the commencement of the work is delayed, there's a contract time associated with this agreement that the contractor has to achieve substantial completion within the contract time. Obviously, if they can't commence when they thought they were going to because the owner isn't providing the adequate financial evidence of their financial arrangements, then the contract time needs to be adjusted appropriately. And 222 is where you find the current following commencement rights to make the request. And again, Cody will go in later and talk about the nature of the conditions that have to be met for the contractor to make a request following commencement of the work. But I will just note that if it relates to a change in the work in the 2017 documents, we added a lot more clarity about what exactly it is that the contractor can stop in terms of the work. If you look at the midway through that section, it says if the owner fails to provide the evidence requested within 14 days, the contractor may immediately stop the work and notify the owner accordingly. But then it goes on to say that if the reason for the request is because, let's say, the owner added a significant scope of work, which would, materially affect the ability of the owner to meet its financial obligations based on, what the contractor previously thought, they can make a request that they get that financial arrangement. But if they'd already made the choice to undertake commencement of the work, and the only reason they're making the request now is because of a change in the work, they can't stop work on all of the work. They can only stop work, or maybe fail to, not commence the work relative to the change. And that was done just to make it a little more fair and reasonable, so that the contractor couldn't use a change to stop all of the work, only the portion that affected that the change is related to, because that's the trigger for making the request for financial information. So prior to commencement of the work, I think I've kind of gone over a lot of this already. We've added the language that the contractor is not required to commence the work until the owner provides the requested evidence, and any resulting delays go into the contract time. So I kind of covered that on the last slide. Nothing new to add here. And same for this slide. We've really kind of gone over the substance of this. But I think what's important about the change in 2017 is not only what I mentioned about what work the contractor is entitled to stop work on, if, for example, if there's material change, but this actually adds the right to stop work, and what the impact would be if the work is stopped for the following commencement of the work period. Again, the contract time will be extended appropriately, and the contract sum will be increased by the amount of the contractor's reasonable cost of shutdown, delay, and startup. So that is, again, we've added a lot more clarity to this provision. If you compared it to the 76 version to the version now, it's probably about 10 lines longer, if not more. But it now provides a lot more clarity around when the requests can be made, what the owner's obligations are once they receive those requests, and what the contractor can do if they don't receive the information that they are looking for, and how that will impact not only contract time but contract sum. So now, somewhat lengthy review of the history. We wanted to make it clear that this ability of the contractor has been in our documents for a long time, and it has evolved over a long time to come from a fairly straightforward, although somewhat ambiguous provision, to a much more detailed and much more clear process and mechanism for the contractor to access this information that attempts to balance the interests of both parties. The contractor needs access to the information, but the owner does not want to be hassled and harassed for this information unnecessarily. So largely unfettered right to get that information prior to commencement of the work. After commencement of the work, there has to be some sort of, I'll say, good faith reason for the contractor to make the request. Now, this language, this process has been in our documents for a long time, 40 plus years, almost 50 now. And but we've never had any kind of form or documents in our library that would help the parties effectuate this process. And so that's what the G728 and the G729 were developed to do, was to provide a mechanism to effectuate essentially what's in section 2.2 right now. And that is for the contractor to make the request, identify the conditions in which it's making the request, and then for the owner to come back and respond. And so to walk you through the substance of those forms, I'm going to pass it off to Cody. He's going to go through the G728 and the G729, and then I'll do a little bit of wrap up at the end, and we'll get you out of here. So Cody, you're up.
Yep, thanks, Mike. So as Mike said, the G728 2024 is the contractor's request for proof of owner financial information. And in developing this form, we basically tracked the language of the A201 and other documents that contain these provisions, just to make sure all the contractor was complying with all the provisions. Mike, if you'll go ahead and click through. Yeah, here we go. So we'll start out with the timing of the request. And this language, once again, tracks the A201 language, but the contractor will select whether the request is being made prior to commencing work on the project, or if the work on the project has already commenced. Go ahead and go to the next slide. If the request is made prior to commencement of the work, there's really no basis required for the contractor to make such a request, and then they also have no obligation to commence work until the owner provides that information. And as we saw earlier, in such a scenario, that time is added to the contract time to make up for the delay in commencement of work. Next slide. Now, if the if the request is made after the commencement of work, there's 3 conditions, and one of which must be present for the contractor to make the request. Failure of payment from the owner to the contractor, if the contractor identifies a reasonable concern regarding the owner's ability to make payments when due, and if a change in the work material changes the contract sum. Now, the contractor with their request in such a scenario must provide any evidence or basis for the request, and which one of these conditions, if or more than one conditions are present, identify that. The next slide. The right to stop work when the request is made after commencement. The owner has 14 days to respond to the request, and if that 14-day period expires, the contractor is enabled to immediately stop work and notify the owner of the stoppage. And as Mike covered, if the request is based on a change in the work that material changes the contract sum, the contractor may only stop work on the portion affected by the change. And then we also added an ability for the contractor to request that the owner's response is notarized. A201 does not require notarization, but when we were discussing these forms with industry experts, there was a split of opinion on whether a contractor would want the response to be notarized. And that's why we provide this blank so the contractor can make that decision regarding notarization. So then the owner's response, G729/2024, and there wasn't really a framework within the A201 to track and when developing this form. So our main goal with this form was to identify the most common sources of funding for construction projects and basically walk through all the information that may be available for each type of funding, and just to give the owner the opportunity to easily see what information could be sufficient for the response. So I'm not going to go through every single section of these types of funding, but there are a couple of things I want to point out. So we'll start with construction loans, which includes basic information regarding borrower, lender, terms of the loan, etc. But the key things to be aware of here is whether the total amount of the loan, or if there's multiple loans of the loans, if that's available for disbursement at this time, and if it's not, what are the hindrances to that disbursement? Are any of the identified loans being used for other projects, or any of the loan funds available for other projects or obligations? Definitely want to know that. So if they say we have, here's our $1 million loan, but only 500,000 is for this project, that needs to be disclosed. And then we provide additional blanks for if there's any pending or anticipated loans, just so you get a full picture of all the construction loans available for the project. If we move on to the equity contributions, we ask for the terms of the equity contribution agreements and whether those equity contributors have fully funded their commitments. And this is just to see what amount of those commitments are available for the project. Once again, with the whole idea of getting a broad scope picture of the financial situation involving this project. And then you'll want to make sure if there's any remaining commitments that are outstanding, what are the terms of getting those funded and when are those commitments supposed to be met? Government funds, type of funding, the agency, source of the funds, and the key terms of each source. A lot of government fundings have specific reporting requirements that the contractor may want to know. And so all those terms can be disclosed in that section. And then the last two, self-funded or other, pretty self-explanatory. The big key here is you want written confirmation of those funds, whatever they may be, and their liquidity, their ability to be accessed. You don't want them to say that they have, X amount of funds that are available, but they're actually tied up in different holdings or what have you. So not only just that those funds exist, but also that they're currently available for the project and are able to be accessed. And then next slide. By default, the G729 makes all the information and documents submitted by the owner in response to a contractor's request to be confidential. And then the contractor's ability to disclose confidential information is identical to the A201 confidentiality provision.
Great, thanks Cody for running through that. I think all this sort of leads to the one last question, which is when is the evidence considered adequate? And there's not a provision in the A201 or any of our agreements that says, well, what counts as reasonable evidence? And I mean, the reality is it's impossible, certainly from a standard reform agreement, but it's hard to say what exactly is reasonable evidence because it's going to depend on project circumstances. And so, if a contractor is going to make this request of the owner, once they get the information, I mean, obviously if the owner doesn't respond at all, there's been no providing of reasonable evidence if the contractor has appropriately made the request. And then, but once they've made the request and the owner has responded, there's no guidance necessarily on what counts as reasonable evidence. And that was kind of one of the reasons we decided to do these forms, was to provide a mechanism and to allow users sort of an idea of what types of owner financing is typical, and what are the types of questions around the financing the contractor should be looking to answer. And so that's why Cody was talking about, for the loans, is it all available, for disbursement on this project? Is it a multi-project loan where, that while the full amount is high, it is to be allocated between other projects? And same for equity. I mean, there may be a promise from all the equity holders to make contributions, but if they haven't actually made those contributions yet, the money may not really be available for the project. In which case the financing would be a bit illusory if you're the contractor who's about to engage in a serious and expensive undertaking in constructing a project. Government funds are frequently there's a lot of triggers for those requirements that have to be met. There may be certain contracting profiles that have to be met on the project in order for the funds to be available. So there's a lot of detail that goes into, you could just write a number down and it might look like there's enough to cover the contract sum, but there's a lot of details that go into the mechanisms behind how these funds can actually be used on the project. And so we try to provide the G729 to provide that context of the types of not only the money, the amounts, but the types of information relative to those amounts that the owner should, that type of information the owner should provide to the contractor. But when that information reaches reasonable evidence, so that the owner or the contractor can either commence the work or continue the work and not stop the work if it's already commenced, is really going to be up to the contractor, and in balancing its risk with the owner's obligation to share information, and how much, at what point does the contractor feel comfortable. And I think that in that balancing act, the contractor is going to have to be aware that stopping work or not commencing the work is a pretty serious step to take on a project. If it were ultimately to be determined that the contractor was acting unreasonably, that it had received reasonable evidence, yet it delayed the project, you can imagine the type of damages that an owner would be looking for from a contractor who was delaying the project unnecessarily after the owner had met its obligation to provide reasonable evidence. So there is a little bit of a balancing act that the contractor is going to have to do. It may just get the information that it needs up front, and it's obvious that the owner is adequately funded. More likely, they're going to get a complex set of information and numbers from the owner on, construction funding can be complex. And so they'll have a lot of information to evaluate and determine whether or not it's in their best interest to commence the work or continue with the work. But there's really no way to answer from the standard form perspective what is reasonable evidence, which is the requirement language from the 8201 and all of our other related documents that have a similar obligation on the owner and allow the contractor or design builder, for that matter, to make these types of requests, depending on the nature of the contract you're in. But once you have that request, it's going to fall on the party requesting the information to make the determination on whether or not it feels the evidence is reasonable, with the potential risk of if they are not acting reasonably in failing to commence or stopping the work, then they could be exposed to some pretty serious damages from the owner. So I hope that at least gave a glimpse into how these documents, how these forms are supposed to operate, what mechanism and what provisions from the 8201 they're trying to effectuate. And I thank everyone for their time. And I will pass it back off to Nadia at this point to wrap us up.
Thanks so much for that insightful presentation to both Mike and Cody. If you're looking for information on our selection of webinars, please visit our Learn page, which is on the next slide. To contact us about our documents or annual subscriptions, please utilize the contact information shared with you here. The information on your screen will be shared in the next few days, including a survey about this webinar, as well as the presentation slides and the video recording. Thank you so much for attending this webinar today. And again, thank you to our speakers. Have a wonderful day, everyone.
Thank you, everybody.